Have you ever wondered what would happen if your community association held a big vote, it failed, and then the board just decided to hold the exact same vote again a few weeks later? I mean, that sounds kind of unfair, right? Well, a really fascinating legal case from back in 2009 dealt with this exact situation. And believe me, the outcome holds a powerful and maybe even surprising lesson for anyone who lives in a planned community.
So let's just really put ourselves in this scenario for a second. An important vote comes up, the community speaks, and the answer is no. But then, boom, less than a month later, you get another notice for the very same vote. Is that even allowed? Can they just keep trying until they get the result they want? That's the big question we're going to unpack today.
Okay, so our story takes place in a community called Clearwater Farms Estates out in Woodell, Arizona. And, like a lot of these neighborhood disputes, it all kicked off because one resident decided to raise their hand and say, hey, wait a minute.
So here are our main players in this little drama. We've got the homeowner, Carl A. Sawicki. He's the one filing the complaint. Then you have the Clearwater Farms Estates Homeowners Association, the board. And stuck right in the middle of it all, we have the community's official rule book, the bylaws. And let me tell you, that document is what this whole thing is going to hinge on.
Because really, when you strip it all away, this wasn't about some personal feud or neighbors not getting along. The whole thing boiled down to a really simple, technical question. What did the community's own rulebook actually allow the board to do?
So, the event that set this whole thing in motion was, you guessed it, a tale of two different votes on the exact same issue, held less than 30 days apart.
Okay, so check out this timeline. On November 6, 2008, the HOA holds a vote to make a change to the bylaws. They had enough people show up, so the vote was valid, but they didn't get the 2/3 majority they needed, so the vote fails. End of story, right? Nope. Just 28 days later, on December 4th, they do it all over again. Same proposal, same rules, but this time, it passes. Now, it's worth noting, this wasn't some super controversial new rule about, what color you can paint your mailbox. The whole reason for the vote was just to update the community's documents to match some recent changes in Arizona state law. It was pretty much a standard procedural kind of thing.
So you can probably see where this is going. This situation created two totally opposite arguments about what was right and what was wrong.
And this is the exact question that Mr. Sawicki took to the authorities. He saw what happened, the failed vote followed by the do-over, and he felt that something about that process was just fundamentally not right.
So Mr. Sawicki's argument was pretty straightforward. He said, look, the first vote failed. That should have been the final word on the matter. To him, holding another vote so quickly just felt improper. But the HOA's defense? Oh, it was brutally simple. They basically said, show us the rule we broke. They argued there was nothing, absolutely nothing, in the bylaws that specifically said they couldn't hold a second vote.
And that, right there, is what this whole legal fight boiled down to. Did the board actually violate a concrete, black and white rule that was written down in their governing documents? Or did they just violate an unwritten expectation, a sort of common sense idea of fairness? That's what the judge had to figure out.
All right, so how did this all shake out? Let's get to the climax of the story, the official decision from the administrative law judge. The judge's entire reasoning really came down to this single quote from his decision. After looking through all the community's documents, he wrote, none of the bylaw provisions either restrict or prohibit a second vote. It was all about what was, or in this case, what wasn't, written in the rulebook. And with that logic, the final verdict was decisive. Mr. Sawicki's complaint was dismissed. The second vote, the one that passed, was allowed to stand. So what's the legal principle at work here? Well, it's something called limited jurisdiction. Basically, the judge's job wasn't to decide if the HOA's actions felt fair or right in some general moral sense. His only task was to see if they broke a specific written rule in their own documents or in state law. And since they hadn't, there was simply no legal case to be made. Okay, so what's the big lesson here for all of us? This isn't just some random story about one guy in Arizona. It's actually a super important lesson for anybody living in a community that has a rulebook. And here it is, the number one takeaway from this whole case. The HOA won because of what wasn't in the rules. It was the silence, the absence of a rule preventing a second vote that ultimately gave them the green light. What isn't written down can be just as important as what is.
So why are we still talking about this case today? Well, because your community's bylaws and CC&Rs aren't just suggestions, they're legally binding contracts. And it teaches us that if a rule doesn't actually exist in writing, it's pretty much impossible to enforce. In the eyes of the law, that silence in the rules is often interpreted as permission. And maybe most importantly, our personal feelings about what's fair just don't stand up in court if no actual written rule was broken. And all of this leaves us with one last really important question for you to think about. It's not about what you assume the rules are or what you think they should be. It all comes down to what's physically written on the page. So do you really know what your community's rulebook says? And maybe even more critically, what it doesn't say?